Good evening, everyone. Thank you so much for coming to the Academy and for joining us at this event. The Academy building has been deserted empty for 3 years, and as its president, it's so good to see its rooms being filled up with people in 3-dimension, as opposed to little boxes on my computer screen. So thank you so much for coming. I'm also here to welcome you as one of the 2 co-directors of the Center for Medical Ethics and Law of the University of Hong Kong. Today we are extremely excited in announcing and celebrating of a book launch of the book co-edited by Daisy, Dr. Daisy Cheung, Ms. Daisy Cheung and Mr. Michael DUNN, entitled Advanced Directives Across Asia, a Comparative Social Legal Perspective. A slightly scary title, but I'm sure it'll be a good read. This is going to be a 2-day event. It'll be today and tomorrow. Today is here, tomorrow back at Hong Kong U. Tonight, we're going to focus on advanced directives in Hong Kong and Singapore. The book I've just mentioned aimed at being the first ever to talk about the development and implementation of AD in Asia, but that's a very broad topic. And since the Academy is concerned mainly about professionalism, our practice in Hong Kong, so I think it's befitting that we are going to focus on the development of AD in Hong Kong, and to compare it with our sister jurisdiction or friendly competitor country, Singapore. Now, there'll be 2 sessions tonight. The first one will be by Daisy and Rebecca, and then we'll have Dr. Evans online sharing the experience from Singapore, and then we'll have a roundtable discussion. We'll try to get home before midnight. Right? So first, I'd like to introduce our first set of speakers, Ms. Daisy Cheung and Ms. Rebecca Lee, and I believe you have their biographer. I won't read out. You can all read that, and I believe Rebecca is going to go first. Okay, thank you so much. We are going to talk about advanced directives in Hong Kong, challenges for healthcare practitioners. Thank you.
Thank you to all of you, and thank you for that very kind and warm introduction. I'm so pleased to be here. This is one of my first in-person events as well, so I'm very pleased to see and to interact with persons in real life as well. So thank you to all of you. So I'm going to talk about a chapter in Hong Kong very, very briefly. So I'm just going to give you a quick outline of what we said in our chapter. So our chapter outlines the developments of advanced directives in Hong Kong, and we examine the legal and practical challenges in promoting the wider use of advanced directives in Hong Kong. So in Hong Kong, with an elderly population, questions have been asked about how we should look after the elderly, how the elderly ought to spend their final days, specifically whether there should be legislation making it easier for people who have lost their mental capacity to refuse certain medical treatment at the end of life. So an advanced directive, also known as a living will, is defined in our book as a statement in which a person with capacity makes an advanced decision in matters concerning their health and welfare, which is to be implemented in the event that the person loses capacity in the future. So what this means is that this document can be made by a mentally competent person to indicate what life-sustaining treatment he does not want if he develops a serious, irreversible illness later. So in the 2000s, the government considered the concept of AD too new to the community, and therefore expressly favored the adoption of a non-legislative approach to the promotion of advanced directives in Hong Kong under the existing common law framework in Hong Kong. So since then, the Hospital Authority has developed extensive guidelines to facilitate the implementation of ADs in Hong Kong. These guidelines, however, are not legally binding. So the lack of a clear legal backing for advanced directives does not afford sufficient certainty and protection to uphold patients' right to self-determination. And these legal uncertainties prompted the government to consider legislative proposals on ADs. The government issued a consultation paper on the subject in 2019 and published the consultation report in July 2020. So in the report, the government confirmed that ADs will get stronger legal backing by drafting new legislation on AD to help uphold the patient's end-of-life treatment preferences. So under the proposal, any mentally competent person who is age 18 or above could make an advance directive to refuse life-sustaining treatment, including artificial nutrition and hydration. The advance directive must be made in writing in the presence of 2 witnesses, one of whom must be a doctor, and neither of whom is a beneficiary of the patient's inheritance. The directive will be applicable if the person with a specified illness becomes terminally ill or enters a persistent vegetative state or goes into an irreversible coma or has other end-of-life illnesses. As long as the person is mentally competent and is not under any undue influence, there are no restrictions as to when a person could make, modified, or revoke an advance directive. Making or modifying an advance directive must be in writing. Revocation could be made verbally or in written form. The proposed new legislation on AD is certainly a step in the right direction in our view, and codifying AD will give legal protection to medical personnel as well as respect the will of the patients made before they lost the capacity to make that call. But despite this welcome legislative move, there are still legal and social cultural barriers to the promotion of advance directives in Hong Kong. And in our presentation today, we're going to be introducing some of these potential practical challenges, which we hope we'll be able to discuss with you and the other panelists in further detail during our roundtable discussion later. So I'll highlight some of the potential challenges. So the first is potential conflicts with the Fire Services Ordinance. So practical difficulties in implementing advance directives may arise as a result of potential conflicts between the advance directives and other statutory provisions, such as the Fire Services Ordinance, which binds emergency rescue personnel to their duty to resuscitate anyone who appears to be in need of prompt medical attention, even though that person has indicated that he does not want this. So the government proposes to resolve the conflict by allowing emergency rescue personnel to accept and enforce DNA CPR forms and safeguarding the emergency rescue personnel who act in good faith and with reasonable care in resuscitating the patient. However, the government do not propose emergency rescue personnel to accept advance directive per se, as it may not be within their expertise to determine the applicability of an advance directive, which requires confirmation that the pre-specified medical condition has arisen. So it remains to be seen whether these changes to the existing law will work in practice. And then another practical challenge that we would like to highlight is whether the AD will be available when it's needed. So in the introductory chapter to our book, the editors have argued that the adoption of ADs has presented distinct challenges because they might be non-existent, they may be uninformed, imprecise, unavailable, inadequate, or unpredictable. And some of these challenges are equally applicable to Hong Kong. And one of them, for example, is whether the AD will be available to the doctors at the point when it's needed. So solutions to this problem have looked to a role for electronic medical records, national registries, or new storage system to facilitate rapid access to information about the existence of AD. The government proposal currently requires that the original AD must be produced to ensure its validity. However, it may be difficult for frail patients to present the original AD, and there might also be risk of misplacement of the document, especially since this document may be a very lengthy one. So some have suggested that maybe we could establish a central registry to store the electronic records of all ADs and then granting access to the relevant healthcare personnel in real time. However, at the moment, the government's view is that there will not be any central registry for ADs, but then a flagging alert is currently set up within the HA clinical management system to facilitate communication, even though the information contained in that system is only going to be used as reference. The government is also considering the feasibility of leveraging on the existing electronic health record sharing system to store and allow access to AD records by designated healthcare professionals. So a further question that we might want to explore is whether it is possible to establish a central repository of electronic ADs to obviate the safekeeping of paper documents. So this is a question that we hoped we could further explore at a roundtable discussion. So I'll hand over to Daisy to talk about the other challenges.
Thank you, Rebecca. So in our chapter, we argued, sorry, I'm moving on to the third potential challenge here, the assessment of mental capacity. And in our chapter, we argued that there was ambiguity in what the test for mental capacity in relation to the making of ADs in Hong Kong should be. And the proposed formulation in the original government proposal is that the medical practitioner must be satisfied that the person has the capability to make an AD, but what this capability entails is not further elaborated upon. And in the chapter, we presented several formulations of the capacity test that might apply, including the common law test for capacity, the capacity test for consent in the mental health ordinance, and the formulations of capacity tests in the hospital authority guidelines. We argued that all of these tests are formulated differently and that legislating a unified statutory test for capacity was highly important to avoid ambiguity in the implementation of ADs by healthcare practitioners. Now, how this ambiguity is ultimately resolved will depend on the formulation in the final version of the AD legislation, although we do note that the Hospital Authority's 2020 guidelines on life-sustaining treatment in the terminally ill was recently updated in 2021 to address the concern that their capacity test included an additional voluntariness requirement, which required that the individual make a free choice, free from pressure. And this has now been separated from the capacity test excuse me, in the latest version of these guidelines. So the fourth challenge is in relation to social, cultural, and familial influences. And this specific challenge here relates to social, cultural influences and the importance of family in our culture. In our chapter, we explore some socio-cultural challenges to ADs, such as the importance of filial piety, which often translates into doing everything to save the patient, even if this is not in line with the patient's preferences. The key role of the family, which has been argued in some literature to be the unit of decision-making in Chinese culture, means that resistance from family will likely pose a challenge both at the stage of the making of the AD, that is, the person will not likely proceed if family members oppose this, and at the stage of implementation, where healthcare practitioners may find it difficult to implement a valid AD if family members are in opposition. And as a response to this, education for family members, which I'll talk about further in a second, as well as reassurances for healthcare practitioners that the decision to implement a valid AD in the face of family objection will be protected, presuming, of course, that these are not legal challenges. So the next challenge is in relation what we call whether people can make ADs. So here we note that only some 1,500 advanced directives were signed by patients of the public healthcare system in 2018. And as discussed in our introductory chapter, the low uptake of ADs might be better understood once one really considers the magnitude of the task that one is expected to do. So as the academics Fagerlin and Schneider ask, how easy is it for a patient to conjure up preferences for unspecifiable futures confronted with unidentifiable maladies with unpredictable treatments, right? It's a really difficult task. And as a response to this, approaches to ADs that are disease-specific have been proposed in other jurisdictions, together with an important role for specialist clinical input that focuses on discussing treatments that are more predictable. And this would, of course, require that both healthcare professionals and the public to be much more informed about ADs. And so in Hong Kong, public awareness has been demonstrated to be particularly low, and effective educational campaigns would not only raise awareness, but also address social cultural issues that we just discussed just now, and these would be a really important intervention. And more effective change will likely come from promoting a cultural shift where family members are able to respect patient choices and supporting medical personnel in carrying them out, which is why the active engagement of family members and carers will be a key component determining the success of such educational campaigns. And finally, our last potential challenge is what we call whether the AD will be honored. And the concern here is that healthcare practitioners may be unsure about how to interpret key aspects of an AD or of the situation arising. How, for example, should clinicians respond if the AD doesn't actually address the specific treatment or presenting condition which has now arisen? So even a very clear and specific directive might require some interpretation by healthcare professionals, which has been shown in other jurisdictions to lead to inconsistent judgments. So it can be said that involving experts, promoting clarity and specificity, all of these can help to minimize uncertainty and the need for interpretation. But the fact is, whenever interpretation is needed, this will inevitably be shaped by the person who is doing the interpreting. And in this process, these professionals will always be exercising their judgment, which can be swayed by institutional culture, the views of colleagues, the presence of a family member, or how each of these individuals weighs the value of autonomy against competing values, such as preserving life in challenging decision-making scenarios. So as we argue in the introduction, this is unfortunately the complex reality of enacting an AD regime that might on the surface look very compelling from a basic legal or ethical standpoint. So that's all we wanted to touch upon in our presentation. Thank you very much for your time. I'll pass it on. Thank you.
Thank you, Daisy. We agreed that we'll keep Q&A towards the end during the roundtable discussion. Right, thank you. Next, we'll have Singapore. Am I correct? Are we ready? Hi, Mr. Chen.
Hi, Gilberto. Thank you.
Oh, hi. I don't know whether
can you hear me?
but I can see you. So welcome to the Academy online. At least we have a good. Yeah, we have a healthy sized audience here today, and we look forward to your sharing from Singapore.
Thank you. So let me just share my slides first, and please let me know if you can't hear me at any point or can't see my slides, but here they are. So thank you for having me. I apologize for persisting in 2 dimensions. Unfortunately, my job responsibilities have kept me in Singapore until for today, and I will only be in Hong Kong tomorrow. But anyway, I was asked this evening to share on particularly difficulties in implementing the Singapore model of advanced directives that is found in our Advanced Medical Directive Act. So let me just say a few things. I probably will not be able to go in detail into all the points that I thought of. So let me just first of all highlight the existing key features of the legislation. The important point to understand about our Advanced Medical Directive Act is that it was intended to be an enabling framework, right? To sort of spur things forward, to experiment, and to allow people to get used to the idea of making and relying on advanced medical directives. And so the legislation basically stipulates who qualifies to make an advanced medical directive. You have to be 21 and above. You cannot be mentally disordered, and so forth. Most critically, the Act is actually widely agreed to or considered to be highly restrictive because you can only execute an AMD, Advanced Medical Directive, in the prescribed statutory form, right? And that statutory form only allows you to refuse extraordinary life-sustaining treatment when you are terminally ill and your death is imminent, right? Beyond that, it is very clear that if you are suffering from some prolonged disorder of consciousness, the EMD framework does not apply to you. If you are desirous of refusing resuscitation under certain circumstances, even outside the bounds of imminent death, the Act does not apply to you, right? So it's a very restrictive framework, but in a sense, it was an exercise in experimenting with this new legal instrument. There are, of course, numerous procedural requirements. 2 witnesses, one of whom must be a family medical practitioner or any other doctor of the patient's choice. And the witness has various statutory roles to ensure that the patient understands and is eligible to make an AMD. Crucially for our system, there is a mandatory central registry. What this means is that your AMD cannot take effect unless you lodge your AMD duly executed in accordance with the Act with the central registry that's run by the Ministry of Health, right? If you don't do that, take that step, your AMD is not of any effect under the Act. So after you make an AMD, how do you put it into effect? Well, the Act stipulates the trigger event. There is only one trigger event. There must be terminal illness where death is imminent and where extraordinary life-sustaining treatment merely prolongs the dying process and the patient lacks, well, I'm using my own language here, own word here, lacks capacity. And then you are under an obligation to search for the AMD in the registry and then implement the standard terms of the AMD. There is a duty on the attending physician of the relevant patient to determine if an AMD is applicable and then to put it into effect. And of course, the important thing that the medical profession was concerned about is that there is statutory protection in doing so, provided they act in good faith and without negligence. The effect of the AMD when it takes effect is to withhold or withdraw life-sustaining treatment, but it does not cover palliative care. And in this respect, it's quite interesting that palliative care extends to the reasonable provision of food and water, and I think the received wisdom is that it would cover clinically assisted nutrition and hydration as well, right? So again, that would not be within the ambit of the statutory AMD. The Act also makes clear that if an AMD is put into effect, it is not to be treated as the legal cause of death, and there are other protections to preserve insurance coverage or health insurance coverage in particular. So let me get to some of the issues that either have been encountered or one can reasonably expect to occur by reason of the way that the framework, the Act has been designed. I briefly mentioned because this seems to be of some concern in Hong Kong, but we have a very awkwardly phrased requirement that the person who executes an AMD must not be suffering from a mental disorder. It's quite curious why they chose this term, because our Mental Capacity Act was also passed at the same time, and they could easily have used the concept of mental capacity under our Mental Capacity Act, but they chose to follow the Mental Health Disorders and Treatments Act and stipulate mental disorder. If you read the Act itself, there are at least 3 distinct concepts of capacity that are embedded within the phenomenon of mental disorder. There is, at some points, a status-based understanding, at other points, an outcome-based understanding, and in some of the regulations, a more functional understanding of capacity required to execute an AMD. My view is the sensible course is just to align with the Mental Capacity Act's understanding of capacity. Secondly, it might surprise you, but Singapore is very fond of criminalizing a lot of things. So there are a lot of criminal prescriptions in the Act. For example, it's a criminal offense to procure an AMD by any deception, fraud, misstatement, unconscionable conduct, or undue influence. We can understand deception, fraud, and misstatement, right? So if you deceive someone into misunderstanding the nature of what they're getting into, yes, that should be disincentivized. But when you expand it to unconscionable conduct or undue influence, it does sort of create this deterrence of getting involved in helping the person, especially if you're a family member that stands to benefit from the estate of the patient in question, because one of the penalties is that you will forfeit your interest if you, have criminally, unduly influenced someone to execute an AMD. There's also, believe it or not, there's also a criminal prescription against healthcare workers from asking if the patient has actually made or intends to make an AMD. Our doctors in Singapore that I've talked to all remember the first part of the criminal offense, which is I can't ask the patient if he or she has made an AMD, but actually there is an exception, except in accordance with good medical practice for public education, right? So actually it is intended that in certain circumstances, it is rightful to ask whether the person would like to or would consider or has in fact made an AMD, but the way the provision is structured really creates a sort of a deterrence to actually opening a conversation about AMDs, unless you're really clear that it is ethical or legitimate. Maybe I should say why it's there. I think if you look at the history of the AMD, there was a lot of public suspicion about the instrument of an AMD, and there was a concern that led to this criminal offense that if the healthcare system or professionals knew that you had executed an AMD, that your treatment might be compromised, or they'd be less keen to attempt efforts at saving your life and things like that. So they didn't want doctors to be able to openly discuss the existence of an AMD. Now, the Act finally also makes very clear that it is not the exclusive form of advanced directives that Singapore recognizes. Right, way back in 1995, when the Act was discussed and its basic draft was promulgated, it was quite clear that they expected common law directives, right, that would be recognized by the common law could coexist and operate together with the Act, but that the Act would provide a surer foundation or framework for the implementation of advanced directives. So the Act makes clear that it does not preclude you from exercising your common law rights to execute other forms of advanced directives. Yeah, so that's quite clear. The problem with this is that the medical profession, at least from comments that I've heard at various fora and discussions, is it's not quite clear what you can do outside the framework of the statutory AMDA, right? So many doctors not even sure if any other directive could take effect, and there's of course still a lot of uncertainty about what formalities might be required and what is official, what is authentic, and what is not. None of that is really addressed by the Act. It just says, well, basically, you can make a common law advanced directive if that is recognized by the common law. Very briefly, there are numerous provisions that require healthcare professionals involved in the making of assisting in the making of an AMDA to keep that process absolutely confidential. So really, unless the doctor, the attending physician happens to also have been involved in helping the patient execute an AMD, no one will really know that this patient has an AMD until the trigger events have been certified and then a search is done. So I imagine actually in most cases, it's equally likely that everyone will just make decisions in pure ignorance of the fact that the patient has actually an AMD in existence. Finally, there's an elaborate process for certifying terminal illness, especially and in particular where death is imminent. Unfortunately, the Act doesn't define what imminent means. It doesn't specify a certain chronology within a month, within a year, within 5 days, nothing. It leaves this to medical judgment, and ultimately initial group of 3 physicians, 2 of which must be specialists, will have to agree by consensus that the trigger events exist. And because of this ambiguity, I can imagine that a lack of consensus would not be uncommon. All right, so to conclude, if you look at some of those challenges in actually making or putting an AMD into effect, it should not surprise you that actually very few AMDs have been made. In about 22 decades, you only have about 25,000 AMDs registered. And in that period, only 10 have actually been implemented, right? But I mean, that said, I don't think we can measure advanced directives in just absolute numbers, or you can't measure the success of the concept of an advanced directive in absolute numbers, but the very low take-up isn't really surprising for any of us. The second point is, and this is not really directly addressed in the legislation, but the Act sort of has a model that presumes that making an AMD and considering it is a very private bilateral relationship between a single patient and his or her physician. And so everything revolves around protecting the sanctity and privacy of that model, when actually for most people in Singapore society, that is a family-based process where other individuals will be involved. So I expect that without that kind of family support, as we see in various studies that have been done of patients and decision-making process, without that family support, most people will probably not come around to thinking seriously about the need for an AMD. And as Daisy mentioned also, I think it's very difficult for many people, even if they're made aware, of actually knowing what they actually want for a future unknown event, for a future unknown illness, right? And finally, the main complaint that I've heard from many senior physicians in the hospital system is that the DMD in its current form is too narrow. It's great in terms of the statutory protection, the central registry, or central registry assessing the authenticity of the AMD, but what if I want to deal with other situations? What do I do then? And there aren't many other guidelines to fall back on. There is only one document that I'm aware of that it's made public, and that's the National Medical Ethics Committee's ethical guidelines on good communications during advanced care planning, where they do actually address the issue of the need for and support for executing other kinds of advanced directives in Singapore. Right, so with that, let me just stop there, and I'm happy to take questions later. Thank you.
Thank you so much. We'll have questions and answers during the roundtable discussion. First, I'd like to introduce my co-chair of the roundtable. The co-editor of the book that I mentioned is Mr. Michael Dung. He is the Associate Professor of Center for Biomedical Ethics at the National University of Singapore. Michael, please. Yeah. And then that's me. And then I would also like to introduce Ms. Shannon Chen, who is from Deacons, and she is the chairperson of the Mental Health Law Committee of the Law Society of Hong Kong, and she also co-chairs the Mental Health, Elder Law and Capacity Subcommittee of STEP Hong Kong. So please, Shannon. Next, I'd like to introduce Mr. Albert Lam, who is a consultant of the Health Bureau, who apparently is looking after this piece of new legislation. So we were just talking about it before we started, that if it goes well, then those credits should go to him. If it doesn't go well, then you can blame him in future. Then, of course, we have Daisy and Rebecca. Please, thank you. Maybe Michael, would you like to say a few words? Thank you.
Thank you, Gilberto, for that introduction. Pleasure to have everybody here today. We want this to be a very conversational roundtable, so we're looking forward to your questions, your comments, your points to the panel. But we will start with a few questions to our invited guests, just to reflect on some of their own personal and professional insights on this matter. Albert, if I could start with you, obviously wonderful to be able to welcome you here today. Any updates you can give us about how things are going in terms of the drafting and of the bill?
Happy to. We have been talking about advanced directives for almost 20 years. In 2004, it was first raised by the Law Reform Commission. Now, next year will be the 20th anniversary. I hope we can do something before that. Earlier this year, we announced a legislative program bills to be introduced into the Legislative Council this year. Among the, within the legislative program, we have included the bill to give effect to advanced medical directives. So that's the latest update. One small step ahead within this year, I hope.
Thank you very much for that. If I may follow on, the challenges that Daisy and Rebecca laid out were numerous, I suppose, and they apply across a whole range of conceptual and practical questions about how the ADs may work in practice. I wonder whether some of those challenges resonate with the experiences you're tackling in the development of the bill. Is a common ground there?
Yes, we conducted a public consultation on end-of-life care back in 2019. And after that, I think we have sort of created or built up a consensus on the way forward in respect of legislating on ADs. We have been working on that despite the other distractions posed by the pandemic and busy law drafting, our Department of Justice colleagues. We have been progressing slowly along the line of legislating on ADs. We have come to the stage that we have a draft bill ready. It's the 9th draft, I think. It's almost, I think, 95%, if not 99% complete. But as always, the final 20%, 5% is always the most difficult thing. So we are moving along. The challenges mentioned by speakers just now, we face all those challenges. One of the challenges is that we don't have public support for that. Back in 2004, we overcome that by doing a public consultation in 2019. We think we have a consensus to move forward, and that's important because back in 2004, very few people knew what an AD is, and very, very few people made an AD. Right now, we have a few thousands people making that, not too many, quite a lot compared with Singapore because they have legislated on that. I hope we can do that as well, more people get into the boat to do what will benefit them during their end of life. The challenges about other legislation like the Fire Services Ordinance, we will be trying to tackle that. A specific point about ambulance personnel not going to respect an AD, that's a moot point. But as far as we understand, ambulancemen, they claim they are not trained as physicians. They cannot make diagnosis. They will not know in a split second. They could not ascertain whether that particular person having a cardiac arrest is suffering from a terminal illness or any other things specified in the AD. But for us, the most important thing is that if that person refused CPR, if 2 doctors previously ascertained that CPR is not in the best interest of that person and issued a DNA CPR, when that person, the family of that person, the carer of that person show that particular document DNA CPR to an ambulanceman, the ambulanceman under the proposed law will respect that particular DNA CPR. So that's a step forward. Because in the split-second situation, ambulancemen, they are going to perform CPR right away, unless somebody produce DNA CPR. They will not have time to study several pages document of ADs to ascertain is this that particular illness, or is this that particular situation that the particular person is facing. So for ambulancemen, they will accept DNA CPR and do not perform CPR if a valid one, an applicable one is produced. There are quite a lot of others, but maybe I'll start with that.
Sure, thank you. Well, we have lots of time to come back to other challenges as well, of course. Gilberto, maybe I can hand back to you to ask the next question.
Maybe we have a few questions from the audience
Sure.
and see how we handle them.
Thank you, Albert, for your advice about the comparison how we can use DNA CPR or advanced directive at the present moment in Hong Kong. Honestly, within the advanced directive form, even for the HA form, there is already mention about whether to do the CPR. And I would think about is if for a community primary care doctor, what they can sign is an advanced directive, but they cannot sign some form like the hospital authority is outside hospital DNA CPR. Why we can't recognize that efforts that have been paid by a lot of the primary care doctor in Hong Kong? And also, as you know, the JCECC under the Hong Kong U and also the Institute of Aging under CUHK have done a lot of groundworks to promote this concept. I agree that for the Eastern culture or Hong Kong culture, family support is very important. And even a lot of good stories, the family fully support DNA CPR without signing any form. And the doctor respect. So good promotion, good education for community, I still think is the first foundation. But what we are talking about at this moment is how we facilitate this to be implemented in the community, because doctors in hospital authority are too busy.
Would you like to answer? It was more like a comment than a question, but any?
Maybe just a clarification. Doctors, in our proposed legislation, 2 doctors will need to sign. We need the DNA CPR to be signed by 2 doctors, one of which must be a specialist. And family doctors, I think, could be one of the doctors to sign those things. And we think that given that CPR is the single most refused treatment in most AMDs, I think it's important that they be allowed to be signed by other family doctors, for instance. The difficulty faced by the ambulancemen is that they can only look at the DNA CPR, which signed by 2 doctors has already certified that that particular person is already suffering from imminent terminal illness. Whereas an AD, it could be valid, but it has not become applicable. Not until the specified condition happens, it may not be applicable. So ambulancemen could not make the decision, but in a hospital or doctor setting, they could determine whether the AD is applicable or not. That's the key difference between DNA CPR and AMD.
Thank you. Please.
I have a question to the President. Do you think the medical profession is ready to perform the assessment of mental capacity? And I think under the MRO, any registered medical practitioner can sign, but are they in full training to do the assessment? I mean, mental capacity assessment.
First of all, the president of the academy can only speak for the specialists and the fellows, which account for half of the doctors, roughly. And among them, it depends on the context, I think. We heard from the 2 speakers earlier on. There are different frameworks. And in fact, that is something I would like to explore with Charlene. What is the likely framework that the AD legislation is going to be adopting? Because that would affect how we are going to assess mental capacity, and therefore the answer to your question, whether we are ready. If our fellows will have to juggle with 3 sets of tests, then the answer is obviously no. So any comments from Ms. Chen?
Testing.
Well, thank you. I think I can only share from a very practical experience, practical side, because as a family lawyer and, well, I did probate, well, almost 30 years ago. We first started and people did not know or cannot accept the idea of even preparing a will, talking about death, end of life. But in the past 5 to 10 years, I've really seen an increased number of people coming when they do the end of life or care planning. They ask about advanced directives in a non-clinical setting. So in a non-clinical setting, they would come to a lawyer's office and then they say, oh, I want to prepare a will, I want to prepare an enduring power of attorney. But I'm also, you know, I'm not in hospital yet, but I know that I've experienced how traumatic it can be for family members to be debating whether or not to refuse life-sustaining treatment when a person is dying or resuscitation. So they come to us and say, we want to be able to prepare an advanced directive so that my children and my family members won't have to go through this. Now, normally, we all know that this is a legal document. You know, both professors have, you know, gone through the document, and it has to be signed by a registered medical doctor, and also any witness that's 18 years or above that does not have an interest in the estate of the maker, the AD maker. So it's not a psychiatrist, it's any registered doctor. So I don't know about your question, but you're talking about, I know that a lot of the Part 2 specialists, they are qualified to assess mental capacity in other tests for, like, for example, in the Part 2 mental health ordinance, to certify that a person has lost the mental capacity to manage the financial affairs. But then for the for this, as I think Rebecca also mentioned, and Daisy mentioned, that it's not quite clear what the doctors have to certify in terms of the mental capacity of the AD maker. So, of course, we all know that mental capacity, you know, has different levels and complexity. It depends on what decision that person is making. So that part has to be clear. But whether or not all doctors are ready to make this mental capacity assessment, I think it's a very good question. But it also depends on what the legislative framework will be, which is not, well, which is, we look forward to receiving that soon. But at the moment when we practice, we actually have a psychiatrist to do the witness, to witness the AD in a non-clinical setting, because that person will be assessed. But similar to Singapore, I think, the family doctor is also preferred, because a family doctor, in fact, next week, we will be attending, a person wants to do an AD in a non-medical setting, non-clinical setting, and it will be in the family doctor's assessment. So I can't answer whether or not it's, it will be all doctors should be able to assess, but I know that for us, we actually, in a non-clinical setting, we would ask a psychiatrist under the Part 2 to do it, not because it's necessary, because according to the HA form, it's any registered doctor. But for us, we prefer to have, because we work on other documents as well, so.
I think it's really interesting, that, Shilin, this idea of there being almost two phases of interpretation challenge. The phase where the AD is first created and how we interpret the person's ability to make that and how that's managed, and then, of course, the implementation of it later on. I'm very interested in what you said about this tension between the formalities of the requirements, particularly assessment of capacity, but also in relationship to form filling and such like, at a point which for many families could be quite a traumatic moment. I mean, there's a sense in which there's a very emotive dimension to the process of setting up this framework. I wonder how that is going to be managed, because I could imagine situations where when you sit down with a family in a non-clinical setting, as you say, and say, we need to bring in the psychiatrist or the family doctor to assess capacity, it doesn't chime comfortably with how the family's presenting. Is that something you've seen from your experience of working at the coalface with your clients?
most of the time, actually, it's only the husband and wife will come together, and the wife will press the husband, says he needs to do it, because otherwise I'm not going to argue with your mother, not your mother, your siblings or whatever, if they, I say that, you should, I agree with the doctor that you should, plug and refuse life-sustaining treatments. But then usually the wife would then go through each and every question, because sometimes I'm also a witness to how the AD is formed in a non-clinical setting. And the wife says, I think I need to go home and think about it. Because once you focus on it, it's actually a very heavy, document asking you to face all these scenarios. But then usually the husbands would execute it, just get on with it. Once I'm here, I want to get it done. I want to get all 3 documents done, and I have a peace of mind. So I think it is very emotional, but the tension that I see is because of the, a lot of times the disputes arise in the hospital. I think a lot of you are doctors here, and you probably have witnessed some of the disputes between family members, and it's not pleasant. And hopefully they don't end up in court.
Just wonder, whether in Singapore have you experienced any challenges rising from debatable mental capacity of the person?
Yeah, I mean, I'll ask Tracey to come in as well, because Tracey's been there much longer than I have and knows this area much better than I do. But I mean, one of the interesting things, even when you have a well-established test of mental capacity that I've seen both in Singapore but also back in the UK, where I'm originally from, and the legislation in Singapore is very much modelled on the English legislation. We have a very clear test of capacity and have for many years. It's a functional test. It relies on an assessment of cognitive and communicative capacities. And interestingly, under the law, it's not just medical professionals who have to make those judgments. Every single person who acts in connection with a care or treatment does. So, if a wife is making a cup of tea for her husband with dementia, she would formally, under the legal requirements, be assessing that man's capacity before she decides on his behalf whether she helps him or not, or what kind of tea he has. So there's an interesting tension, I think, in any legislation here, that we're going to have to rely on some test. It's going to require some assessment of cognitive function, and we need to work with that test continually and constantly all the time, because it marks out decisional abilities. Now, of course, for formal processes like ADs, we can rely on a much more considered assessment. But these issues apply all the time for any test of capacity when we're thinking about making decisions on behalf of people. And I think there's a heuristic that doctors apply. Certainly I've seen that in Singapore. They have rules of thumb, judgments that they make. And that's generally seen as okay. But I do agree with the other members of the panel that when it comes to a formal process like this, we do have to think a bit more carefully about how we professionalize that assessment in the right kind of way. Tracey, I don't know whether you have anything to add from the Singapore context about the workability and the applicability of the assessment of capacity.
Maybe I'll just make 2 points. The first is the AMD is probably not a good example of what to do. In fact, it's probably a bad example on many counts. But part of the reason is when it was first passed, I think the country was, in particular lawyers, were less familiar with various concepts about decision-making capacity, what a functional test is, and so forth, right? So there's, I think originally there was a great lack of familiarity, but so this leads me to the second point. So we had to go through this whole leveling up in terms of getting people, general practitioners, doctors, and even some lawyers are familiar with the statutory concept of mental capacity under the Mental Capacity Act, right? And so what they did basically was, they had training programs and they identified people who were going to be involved in the process, because at that time what they were trying to encourage people to do was to execute lasting powers of attorney or durable powers of attorney. So once they decided that that was the policy, then they had to identify who were the likely professionals that were going to have to assess capacity, what is the basic training that they need, and then the Singapore Medical Association ran numerous training programs. I think some of the materials are actually online somewhere, and such like, right? So there is this implementation aspect of it, where you really have to target, identify the people that are going to have to do this work, train them for it, and then they will be ready. Right. So today you can actually go to an MOH website and find general practitioners in the community that have been trained and are ready to witness and certify a mental capacity to execute a lasting power of attorney. Right. So I think that's probably a good analogy to doing something for advanced directives.
Okay, thank you very much for the excellent presentation. I just one question, because sometimes the cognitive function, as well as elderly, fluctuate from time to time. There will be good days or bad day, right? Probably we as a doctor, we probably will make sure the cognitive function at that moment. We cannot predict what's going to happen. I can't predict what's going to happen to me in 3 weeks' time. So maybe on a good day, all right, they witness and they sign the assess the mental capacity to do so. Maybe in a couple weeks or months later, they decline. Sometimes the relative or family member may go against, look, come on, that chap, that my dad, my mom has declined already. How could that Dr. A signed, certified a few months or a few weeks ago? So that making the doctor in a very difficult situation. I wonder whether our expert could enlighten us further, or some of the frontline doctor, because it's supposed to be a good day. They should make the capacity, all right? They have the autonomy to decide, but maybe a few weeks later they decline, and the family think maybe my dad and mom hasn't made the right decision, and then challenge the decision. It's happened from time to time. So
fluctuations in mental capacity.
Thank you, Albert, for your question. So I'm obviously not an expert in the sort of practical implementation of this, but and Mikey will probably know a bit more from the UK context. But what that brings to mind is the importance of having principles behind this sort of statutory unified test for capacity, which is the principles that come along with that test. So for example, as I understand in the UK context, there is the principle that you are, in the Mental Capacity Act Code of Practice, there are lots of rules in place to ensure that you're helping that person make a decision at the time that they're most able to make that decision. So for example, you consider things like the timing, the location, the time of day that they're most lucid, or and so there's the idea there is that you're trying to enable them, support them to make the decision when they can. So when they reach their sort of peak capacity at a certain time of day or a certain time over a period. So in that particular scenario that you raised, I personally wouldn't see any issue with that, because at the time that the AD was made, the person did indeed have the capacity to do so and was assessed to have the capacity to do so. If the family then says, well, then this person subsequently lost capacity, well, then that is a separate matter as to whether the AD should be implemented or whatnot. But at the time that it was signed, that was an expression of the person's autonomy at a point in time when they had capacity. So I personally don't really see any problem with that particular scenario. I don't know if I've misinterpreted the UK context.
No, I don't think so. But I think it does raise this important question about getting timing right for the assessment of capacity quite clearly. Also, questions about revocation, I guess, come up as well, Daisy, don't they? Because, what if the person then decides 2 weeks later, actually, you know what, I don't want to go ahead with that document I signed. Is that something that's being addressed at all? Do we know?
Who should speak about this, but as far as I know, revocation still requires capacity, although it's done in a much more simple way. So I also had this question as I was reading the legislation. So who's going to assess capacity at the point of revocation, if it's sort of, you can tear it up or you can draw a line through it? So I don't know if Albert has anything to add.
Yeah, our thinking process during the drafting stage is that for AMDs, we would suggest people to do it very, very carefully after discussion with various people, your doctors, your family, and then come to the decision to sign an AD. It needs to be carefully thought out, prudent, and but we also add that you can change your mind anytime. So when you sign that particular document, it's a very formal procedure. You need witnesses to certify that you are capable of doing it. You have the capacity to do that. You understand the circumstances, you understand the result of signing that document, which is an earlier death, so to speak. But as regards revocation, we think that we will make it very easy. You change your mind, well, that's it. Tear it up, cross it over, tear it up, burn it, just don't produce it. Anytime you do any act like that, you revoke that AD. You tell a person, tell a family member, tell a doctor about it, verbal revocation, we accept that also. So it's difficult to get in, but very, very easy to get out. For whatever reason you change your mind, we respect that right at that particular moment.
Just the question, is the revocation revocable? Can you change your mind about changing your mind and then back again?
I think it would be prudent to sign another AD after you have revoked the original one. Because
So
you have
haven't
to
torn up your genuine copy, original copy, and just keep using it, but then you change your mind every 5 minutes. I mean, I'm creating a
Yes, I know.
scenario just to help for the help.
Once you intimate to somebody that you revoke the AD, that is revoked. So when you need you want to revert back to square one, we require you to make a very careful consideration again. Get two witnesses to sign the document for you. Certify that you know again, you understand again the consequences of signing that AD.
But then that's without someone certifying your capacity when you revoke it, because wouldn't that defeat the whole purpose of autonomy? Because like what Daisy, I know it's not your personal judgment, but like what Daisy was saying, you want to make sure that the person was making a decision at his best time, but then he might deteriorate later and then revoke it. Wouldn't that be not doing the person a favor?
It's a tight spot. There's no perfect solution for that. But the general principle for ADs or for many end-of-life measures is that when in doubt, well, save life first. So in that case, when you revoke, I wonder about whether that revocation is valid or not. You treat it as valid.
And at that point, do you need to have mental assessment as well? You want to revoke or revoke? Yes, at that point, do they have to have a mental assessment to withdraw or revoke the AD?
Yeah. As I mentioned earlier, when you make a verbal revocation, that's it. You revoked it. Nobody needs to certify that you have capacity at that point in time. We play safe. When you revoke, you revoked.
Rebecca was going to say something. Am I correct? No, just okay.
Yeah, because I was just going to add. So if the maker of the AD has gone through the various serious procedures very carefully, then why is the law allowing him or her to revoke it so lightly? So I think you've addressed it by saying that, well, maybe we go back to the first principles, save lives first. So I think, but I can see that there may be, potential contradictions here.
Can I ask a question? It's about the oral revocation. Is it to be witnessed by at least record the decision? My understanding is that it's prudent to have, when the person wants to revoke it orally and tell someone, then that person would at least record that decision in writing. Is that something to be considered? And how is it practiced in Singapore, for example? I know Tracey's here.
Maybe let me start by saying what we are thinking first. In terms of verbal revocation, it takes immediate effect. But the conveyor of that message, the witness, will need to convey that revocation to the doctors so that they can continue with life-sustaining treatment if necessary, and that sort of thing. About why we are accepting a verbal revocation when the patient, that particular person, has gone through a very careful process of signing an AD and then revoke all of a sudden. I would say I can't tell, because any particular individual can change his or her mind at any time for whatever reason that at that particular point in time, he or she thinks is good for himself or herself. Maybe, somebody mentioned, maybe she wants to, well, witness the birth of her grandkid. Maybe 100th anniversary is coming up. For whatever reason, we don't need them to justify that. They just say it, and we respect that. We don't need them to go through a particular test to say whether it's valid. You have gone through that. Now you change your mind. That's not fair. No, we don't do that. We respect their change of mind as well.
Interesting to set a lower bar for revocation potentially than the initial formulation. You might think because of the values at stake that's reasonable, that the withdrawal of the statement is in some sense less morally problematic than its original formulation. I can see that argument. Tracey, Shirley, I wonder whether you had something to offer from the Singapore side on the challenges of revocation.
Yeah, so I think the current Singapore position largely reflects what was mentioned by the panel. First, there is no requirement that you must be assessed again to have capacity to revoke the AMD, but there is a requirement, and you can do so orally or in writing, but there is a requirement for at least one witness for the revocation. Obviously, to authenticate that it actually happened. And there is also this, I'm not sure how effective it is, but there is a legal obligation on the witness to notify the registry as soon as practicable that the AMD in question has been revoked by the individual. So that's our current position. Why that is the case, I think, I can't recall the specific deliberations of the select committee, but in addition to the idea that the fact is people can change their minds, the ability to change their minds with ease, I think also reassures people to encourage them to actually make the AMD to begin with, right? Because if you're going to get yourself into a situation where everyone is going to be bound by a document with very serious consequences, life and death most of the time, people want the assurance that I will be able to get out of that decision if I change my mind. And this is equally respectful of autonomy because people change, right? The studies show people actually change their views quite often. So yeah, and the third point I would make is this, right? So yes, we insist on capacity when you make the MD, that you have the capacity to make this important decision. You may change your mind, but in a sense, the point is, without the AMD, it doesn't mean that all treatment must go on, nothing else can be done. No, the usual other processes of decision making will continue to exist and can be fallen back on, right? Instead of it, it's just basically the harshness, if you want to call it, of the way the AMD operates. Once it's binding, you have to respect it, regardless of what else arises in the future, what other considerations. I think it's that harshness that probably explains why it's much easier to revoke than to execute an AMD. Yeah.
Joseph?
Can I ask Albert, what is the thinking behind the government for not having a registry, a central registry? Prof, it gives some sort of order to the whole thing, right? So what is the thinking behind?
We have taken reference from overseas jurisdictions, Singapore including. We have mentioned the pros and cons in the consultation document as well as the report, so I'm not going to repeat it. But when drafting the bill, the most practical difficulty against central registry is about what we talked about just now, revocation. If you revoke verbally, it will take some time for it to be reflected in the database. In this day and age, I can take out a telephone and then erase whatever in the database. Maybe so, but think about a frail person about to lose consciousness, but somehow he thinks that he wants to witness certain thing next week, so he wants to revoke it right now. When you have a central registry, the time lag between revocation and reflection in the registry, right now it may take a time indeterminate. I can't tell whether it's easy to do that or not. But so when we're drafting the bill, this comes up and we can't resolve it satisfactorily right now. But further down the road, we think that with the development of the electronic record, electronic health record, storing your AD in it, and then you have the capability to amend it yourself, revoke it yourself. When that particular capability can be exercised, can be implemented very fluently or easily for most of the population, I think at that point in time, we will think about a central registry later on. But at this point in time, we have not overcome the instant revocation issue yet.
But certainly not having a registry doesn't solve that problem either. Am I correct? Yeah. Because then you are ignoring, well, presumably the majority of AD makers who haven't revoked for the sake of one or two who might have revoked, but then without a registry, you still wouldn't know. So you're back to square one. Am I correct?
We don't have the perfect solution. And AD is a very important document. Public education is very important to enable it to be implemented successfully. When signing the AD, we want the witnesses to help educate the maker that this is a very important document. Store it with your medical records, identity documents, when you've come to the stage that the AD will become applicable. So when the AD is presented to the doctor, they will know what to do or what not to do. With the central registry, the onus will be on the doctor to check the registry, whether there is a valid AD there. It's quite different if we insist on the original or a true copy of the AD. When a particular person signing an AD does not present the AD to the doctor, it may mean something. It may mean that he wants to revoke it. He doesn't want it to be applicable at that point in time. Vis-a-vis a central registry is there. You can't change your mind in an instant. These are also the difficult situations that we have to deal with. We have no perfect solution for that.
Yeah, so I think another issue is about electronic copies and the original documents. So at the moment, only original documents are recognized. So we are also hoping that the government will legislate and to have, to accept electronic documents like in Singapore. But is it appropriate for me to maybe go through some of the, because I'm also part of a charity called MIP Care Resources Connect, and it's Hong Kong's first charitable organization to focus on providing information, resources, and support to family members and caregivers of mentally incapacitated persons. So in 2021, we actually conducted an online survey with the sample size of 1,014 respondents aged 25 and above. It's because, as I mentioned, enduring powers of attorney, wills, and advanced directives are now sometimes dealt with together, and we refer it to the three instruments of peace. So I just want to give you an executive summary of how the survey was conducted to find out how people store these three documents, the EPA, Advanced Directive, and wills, but we're focusing on Advanced Directives today. Now, we also want to understand the public's view on the idea of establishing a central depository for storage and timely retrieval of these documents. So it's interesting to note from the survey that most people store their Advanced Directives at home in their drawers. And 40% of the respondents who have made Advanced Directives are concerned about the safety of the current place of storage. And interestingly, 1/3 of the AD makers did not inform the family members of the storage location. So how will you be able to get the original document in time? So that has also been an issue. And then the survey also concluded that 85% of respondents think that Hong Kong has a need for a central depository. And 83% indicated that they will use the central depository if there is one. And 82% of the government says that the government should be involved in the supervision or management of the central depository. In fact, let me see, summary here. Oh, okay, I'll summarize that later. But 72% believes that the judiciary, 49% believes that the hospital authority, and 33% believes that the social welfare department should be involved in the establishment of a central depository. So if the respondents also say that if the central depository is to be set up, there are 4 issues that they are most concerned with. One is safety, second is the privacy, third is regulatory oversight, and then timeliness. I think timeliness is in relation to the retrieval. And also who should have access to these documents. 77% agreed that registered doctors, whether they're at government hospitals or private hospitals, should be able to access these advanced directives from the central depository. And 81% believe that certified digital copies should be stored in the central depository, and 67% actually wanted the original copy to be stored. This is on the basis that Hong Kong legislation only recognizes the original document. But people also indicated that they prefer to submit documents to the central depository in person or via online and request access online. So I think we're moving towards, the public is actually quite prepared. I think from maybe 10 years ago, they were not very prepared to use electronic copies or access. But and the most important thing is that the public that were did the survey, 67% says that the service should be free of charge. But I think I also want to share a little bit more. So this is the summary. I also want to share a little bit more about the symposium that was held on 16th of March this year. And we actually invited Dr. Bernard Chan was the guest of honor. And then we had panel speakers from medical, legal, social welfare, and technology fields. And we discussed about the possibility of setting up, or the feasibility of setting up, a central depository for all 3 documents. But I think Dr. Lam indicated that the burden, he agreed that the burden of whether or not to resuscitate a person's life should not be left to the family members to decide, because they're already sort of in a very difficult and emotional state. So it's helpful to have the patient himself, part of patient's rights, to be able to indicate that. But I know that in hospitals you have the advanced care planning, and if people who are already inpatients do have that time to do that. But for persons who prepared an AD in a non-clinical setting, I think it's timely retrieval and having a place to locate and store the advanced directive is actually quite important. And I really like the idea that Tracey mentioned in Singapore is it's all electronic. It's electronically recognized, and you can also retrieve it electronically. The doctors can go in. And I remember at the symposium, I was told by Mr. Yan, CEO of Cyberport, and he said that all the technology is there. And he also, I think, gave an example, is that, many years ago, an 80-year-old person will not be using an iPad. But if you tell them that you can see your grandkids' photos in it, they will immediately learn how to use it. So I think it's something that can be learned, can be used. And I think if the technology is there, it's a matter of policy and I think community acceptance and education. So that's what we've been, the charity has been trying to promote. And I think this is a very helpful sort of platform for us to discuss. And I do hope that we will make some progress. And thank you for, having this. That's the end of my sharing.
Thank you. I think that for the last 3 years, we had very good training when it comes to IT
Yes.
savviness. And I got my car, I got a ticket the other day. The guy had no problem retrieving all my driving offenses. Comments?
I really show empathy to Albert because he only represents Health Bureau. We cannot move the Social Welfare Department, which is the Labor and Welfare Bureau, and also the Judiciary. But honestly, more than 90% or even 95% of the Hong Kong citizens would die in hospital authority. So within the hospital authority, already in the CMS system, the DNA, CPR, and the AD already can be alerted. And also nowadays, our MRI and CT in the private setting can be uploaded. And we also now sign e-consent already to start as a pilot in hospital authority. So I see that everything is ready. It can be first pilot in the hospital authority. And honestly, if every doctor have to make certain kind of another assessment before signing the DNA, CPR, and AD, I think it will be too complicated for the public sector to try to move this on. And so if we try to facilitate the community doctor to do this, you foresee that if you impose a lot of different kind of the rules or the guidelines or the tests, first, it increase the cost. Second, it will not facilitate the things to move forward. Then why we do those kind of things for 20 years? And then we still cannot move this even after the legislation. I hope this is not what we want for the future of an aging society.
Thank you so much. Any other questions, comments? At the back.
Hello, my name is Daniel. I'm a geriatrician working in the public hospital system. So I try to speak in the point of view of a physician. In fact, there are a lot to say and ask, but in the interest of time, I'll save some questions for tomorrow evening. But just a few points. I have a special interest in end-of-life care. So these kind of conversations, in fact, is part of my daily work. In fact, I just had this conversation this morning with a patient's family. And I myself has signed about 10 ADs with patients. But I'm very glad that Ms. Chan, one of the panelists, mentioned advanced care planning, because in the College of Physicians, we are in fact promulgating the idea of advanced care plan before advanced directives. Because it was just mentioned, a lot of challenges facing the process of signing AD is that, for example, some healthy individuals wish to sign an advanced directive, but in fact they do not have any idea of what kind of things that they are refusing. Probably at that moment they refuse something, but if they really experience that kind of treatment, they want it in contrast. So this is just one of the examples. And another example would be, some people mentioned that, a person would revoke the AD because he suddenly thinks that it is his 100th anniversary tomorrow. To prevent this from happening, in fact, we are trying to promote the idea of advanced care plan, because advanced care planning is the process where the patient and the family could sit together to think more thoroughly of what they want and what they not want. And because advanced care planning is not only medical issues, it's in fact psychosocial and spiritual issues. So when a person and a family goes through these processes, in fact, those kind of challenges can be tackled, if not all, but can be tackled in part, I would say. So in fact, I would strongly advocate the idea of advanced care planning before signing advanced directives to prevent those challenges from happening. The second point I want to make is that, again, as a physician and as a doctor in the public system, and under the era of fear of being manslaughtered or being sued of manslaughtering a patient, I would also want to ask the panelists, how can a doctor be protected? Or I would say, put it this way, is it the doctor's liability to identify the validity of the AD if a patient shows an AD to you upon the point of care? This is my question.
Before we get to that, Daniel, if I may, thank you so much. I think that's a really important set of points you've made to start us off there. So, I mean, I take it that when we think about planning for the end of life, or we think about planning for our future healthcare, it's got to be a multifaceted approach. We can't simply rely on one solution. And I think the idea that ADs are going to solve all of these problems is not going to work. We clearly need a robust mode of care planning. I think that's absolutely right. It also brings into focus, I think, this role for both the individual and the family in those conversations. And I think we should see that unit in that way, and just as Daisy and Rebecca suggested. On the question of liability, who would like to take that one?
I take care of tough questions. I can't agree more with you about the ACP process. ACP is more important. When you go through that process, the family, the friends, the carers, whoever, presumably they want to get in and make a decision. The final decision, of course, is for the patient himself. But when you go through that process and engage others, it's always helpful. The AD is the only one of the possible end product of an ACP. So it's an instrument. It's very blunt. So the ACP is the process that is more important. About liability, one of the reasons why we legislate on AD is that we want to give certainty and to give protection to medical doctors who help sign ADs, who help implement AD to respect the wishes of the makers, so long as they act honestly and within reasonable considerations, they are protected. If they respect a valid and applicable AD, they are protected. If they suspect that the AD is not valid or not applicable, they are also protected. Either way, the term is about validity. To help enhance to make it easier to check the validity of an AD, in the proposed bill, we will include a model form. That means if the maker complete the form, each and every blanket is filled, they sign properly with 2 witnesses signed, so they complete the model form, it helps enhance the validity of the form. So once the form is presented to a doctor, the doctor will need to check whether the form is completed in full, whether the situation or the circumstances mentioned in the AD form is applicable at that point in time. The doctor still has to make a decision about whether the form is valid and applicable.
Just wonder, what if a doctor unreasonably failed to implement an AD? Would there be liability?
You mean there is a AD signed refusing CPR,
yeah, and
then
then
the doctor
refused to acknowledge that, and he thought he should save this patient's life and saved it?
Yeah, I will hope that the Academy will have educated all doctors about respecting the law once it's been enacted. Just an aside, in Singapore, I think they have introduced some penalties or offenses. in our law, in the Hong Kong law, we also introduced some penalties for offenses. But to put it very clearly, these penalties or these offenses are not related to doctors per se. Mostly the offenses are for falsifying ADs, misrepresenting certain things to produce an AD, or deliberately doing some malicious about or hiding or falsely saying that an AD has been revoked, or falsely saying that the AD has not been revoked when it has been. So it's not particularly related to doctors, but for all persons producing or dealing with ADs.
I just wanted to add a point, which sort of we found this from our overview, or sort of looking at all the chapters in the book. It was actually quite interesting how few jurisdictions in Asia actually prescribe this sort of penalty for not implementing an AD. So there are always all sorts of protections for healthcare practitioners for implementing an AD incorrectly or in good faith. But apart from Singapore, of course, there's Taiwan, and Taiwan has those two sort of legislative regimes. And the earlier one had a really strict penalty for not implementing the AD. And then they had the more recent one, the Patient Right to Autonomy Act, where they took away all of those penalties after a series of negotiations with the healthcare sector, who were very unhappy about these penalties. But those two regimes currently apply in parallel. So there's some ambiguity as to what happens if a person is terminally ill and they have assigned AD, which regime applies. But which is to say that usually this kind of criminal offense is really difficult to get into the legislation, I think, precisely because there may be concerns from the healthcare sector.
If I could just quickly jump in here. I did a double check, but whilst there are many offences in the Act, there is no particular penalty for failing to discharge your duty as a matter of criminal law. But I would think that there are at least two basic consequences in Singapore. First of all, you may have committed a civil wrong if you administer treatment against the terms of an advance directive, right? So you may have committed a battery if you ignore the terms of a directive. But certainly also there would be a potential for a complaint before the SMC for failing to honor the terms of a directive. And I think that would be either professional misconduct or other such disciplinary offense, right? So those would be the means of enforcing, upholding the duty to actually respect a valid EMD. Yeah.
Right. Just worrying. Any questions, comments? Okay. If not, then I think time's up. So we can all see that it's a very complex topic. So I don't know how Michael and Daisy managed to actually look at not one jurisdiction, but more than 10 jurisdictions on AD. And so I think this is a book worth buying. So it's open access.
You don't need to buy it. It's free to access.
But I would also like to formally thank our guest tonight, especially Albert, who took all the very tough questions that we fired at him. I think he actually expected it, but probably not as bad as this. But I'm sorry, but I'm very grateful that you're here today to help us clarify many issues. Also, thank you, Shani, for your very insightful survey. I think that's very illuminating about the Central Registry, and Rebecca, Daisy, and of course Michael, and Tracey from Singapore. Hope I'll be able to see you in 3 dimensions very soon. Okay. Well, thank you again, everyone, for coming. Have a safe journey home. Thank you.